We are all set.
Hey, good morning, everyone. I'm Christina Werther, acting chair today, and I call this meeting of the Citizens Clean Elections Commission to order. It is 10:01 a.m. on August 27th, 2026. Today's meeting is being held virtually. With that, we'll take attendance. Commissioners, please identify yourselves for the record.
Sam Crump.
Galen Payton.
Steve Titla.
And Mark Kimball is absent, and so we have 4 commissioners who are present, and we have a quorum. For item number 2, discussion and possible action on the meeting minutes for July 23rd, August 4th, and August 14th. Commissioners, you have the minutes in your packets. Is there any discussion? Hearing none, is there a motion to approve the minutes for these 3 meetings?
I'll move their approval.
Second, Steve Titla.
Commissioner Crump has made the motion to approve the minutes. Commissioner Titla has seconded. I'll call the roll. Commissioner Crump?
Aye.
Commissioner Payton?
Aye.
Commissioner Titla?
Aye.
And chair votes aye. So the minutes are approved 4-0. Item number 3 is the executive director's report, including enforcement and regulatory updates, and an update on participating candidates. Tom, would you please provide the highlights of your report?
Tom, you are muted.
I apologize. Chair Werther, members of the commission, I just want to make a few highlights from the executive director report. First, the general election voter education guide has gone to print. We had 208 candidates eligible for inclusion, and importantly, we were able to include the lieutenant governor candidates in the guide. So we did cancel the supplemental mailing. I think we provided some notice that we were anticipating that might happen if this came to pass, and so that did. So I think that worked out well. Our general election debates are underway. The full schedule and candidate RSVP information is available on our website, and we look forward to continuing to receive voter questions. And we are completing our pre-general election voter survey that identifies issues voters are most concerned about heading into November. So we'll provide that information to our moderators and candidates as part of our effort to ensure that our debate program is optimized. As you can see from the report, we continue to have a robust outreach effort ongoing. In particular, National Voter Registration Day will be coming up, and Avery and others are working with the universities on activities that are going to be going on that day. We finished the primary with 47 participating candidates, and our primary audits are now underway. There's a number of things in the legal section. I really only wanted to touch on one. Many of you may have seen earlier this week the U.S. Supreme Court's decision in a case called Trump versus California concerning efforts by the federal government to that would impact mail-in voting. At the same time, with this week, the United States Postal Service issued a new rule, the final rule on mail voting and its involvement there. We are monitoring that. I know Gina is already working to analyze the rule, and when and if that goes into effect, there will be a significant lift, I think, by all election officials around the state to educate folks. Now, we don't know if that's going to be for this election cycle or not. But as published and finalized, I think the major takeaway is that this will shift significant responsibilities that currently begin and end with state and local officials to the federal government, and therefore change how individual voters who use vote by mail, ensure that they receive their ballot, and that is going to be, a very significant development procedurally for them, and a major educational effort for everyone. So, I frankly, the rule is a little bit too complicated for me to try to summarize now, but I do want to flag that and recognize that, that Gina is already looking at that. So with that, I'd complete my report unless you have questions.
Tom, I just had a question. I thought maybe I saw this morning, so I know it's just this morning, that maybe Arizona was joining in a lawsuit now that the rule has been finalized.
That is, Commissioner Werther, yes, that's correct. And among the challenges there are whether or not there's any statutory authority to even for the USPS to be doing this, right? If you look at the Enabling Act of the United States Postal Service, which I happen to have done, there's really no, if we were writing a rule with the basis in law that this rule has, I suspect that the GERC staff attorneys would probably tell us to go back and work on it some more.
And I guess if there is, I guess obviously depending on what happens with the litigation and the rule, are we able as the commission to be able to, I guess, how are we going to do it? I guess voter education.
Well, I would just say that, at this point, Gina may have specific ideas on how we do that. In the time frame we have, if this were implemented between now and November, the lift for election officials in terms of the way in which data would have to be transmitted to the USPS in order for the list that would be permissible for use of USPS itself is complex and really fraught with places for error that will be borne by voters in the first place. So that part itself, just the doing of it is complex enough. So I'm Gina, maybe I don't know if you've had any thoughts on what we might do on the voters education side. I would defer to Gina, Madam Chair.
Madam Chair, may I?
Yes, please, Gina.
Yes, Madam Chair, Commissioners, I think right now the most important thing for voters to understand is that they have options. And so first and foremost, you can track your ballot. And so if you choose the vote by mail method, it's a fantastic tool that voters have to track the status of their ballot all the way from, okay, is my ballot being, prepared? Was it mailed to me? So when you know your ballot was mailed to you, then that tells you, okay, I should be checking my mailbox here any day now. And then when they receive their ballot, returning it. So making sure voters understand how they can track their ballot and to what options they have if they how they want to return their voted ballot. Do they want to use a secured ballot drop box? Do they want to drop it off at a in-person voting location or on election day? And then if they decide, or for whatever reason, if they don't receive their ballot, they can always go to an in-person voting location. And so I know our counties are considering increasing the amount of in-person early voting locations that are available to voters. And so we will help with the education on that. So I think, there's obviously the administrative side of things and the heavy lift that Tom was speaking to, and of course the legalities surrounding it. But from the voter perspective, they need to just be aware of their options and what to do if they requested an early ballot and it didn't come. How, what options are available to still vote, and then also tracking their ballot. So those are things that we always educate on. We can just amp them up, as we progress through this. But importantly, voters need to understand the options that are available to them and to really be proactive. So understanding this is when early ballots go out. You should have had your ballot in the mail by now. If you didn't, this is what you can do, and tracking the status of their ballot. So it's going to be really those procedural things, making sure that voters understand what options are available to them as they navigate through the vote by mail process in the event that they didn't get their ballot.
Okay, thank you, Gina, and I appreciate that you and Tom have already started to think through this. Did any of the commissioners have any other questions on this matter or the executive director's report? Okay, seeing none, there's no action item on this, so we'll just move on to item number 4. That is the review. Item 4 is a review, consideration, discussion, analysis, and possible action on Dr. Ralph Heap's request for a compliance order in MUR 26-06. So the order of this item will be as follows. First, we'll hear from Tom Collins, our executive director. Second, we'll hear from Tim Lasota, who I believe is online, who represents Dr. Heap. And then we'll take any public comments on this item. Again, Mr. Lasota has, who represents Dr. Heap, has requested the issuance of a notice or compliance order under ARS Section 16-957. The executive director submitted a letter dated August 25th, 2026 for the commission's review regarding the statutory process and a draft form of order. The commission is represented in this matter by independent counsel Craig Morgan of Taft Law. And then as indicated on the agenda, at any time, the commission may vote to go into executive session for discussion or consultation for legal advice with its attorney pursuant to ARS Section 38-431.03A3. And neither the executive director nor Mr. Lasota nor the public will be allowed in executive session pursuant to state law. So I'll just start first by asking Tom to discuss the compliance process.
Thank you, Madam Chair, and I don't want to, belabor this point too much, but, we received the request. I think probably the most important thing is we certainly, as staff, don't have an objection to the request, and we've prepared a form that is essentially based on the reason to believe vote the commission made last week. I think that the important aspects of 16957 are, that it does provide for the issuance of this notice or order. It does provide for this compliance period. That process does not short circuit or put anyone in a position where the commission agencies investigation of this is forestalled or doesn't occur. It's not an opportunity it's not a thing that where everything that is in the order has to be something that can be complied with, and I think that's an important point because there's language in there that I know some people read in other contexts where the language is slightly different to say that the only issue is compliance, and after compliance the matter's resolved. That's not what 16957 says at all. It says that there's time to come into compliance and there's also an opportunity for an explanation. It does make clear that the mere fact of compliance with a reporting requirement by filing a late report doesn't eliminate the late report, right? Otherwise, there would be no purpose to the good cause consideration and explanation procedures. After the 14-day period expires, the commission need not immediately, and nothing in the statutory language says that the commission need or ought immediately make a determination of whether or not someone is out of compliance or not. And, we are in the process of acting on the vote the commission made at its last meeting regarding reasonably. So with that, as I say, we don't anticipate, we didn't develop the draft order in the anticipation there'd be too many questions about it. It really is designed to hew to the commission's vote on the reason to believe determination at its last meeting. So unless Chairwoman or Commissioners, you have any questions, I think that concludes my comments.
Are there any questions for Tom from the commissioners? If not, we'll move to comments from Mr. Lasota. I believe you're here representing Dr. Heap.
Yes, thank you, Madam Chair. Mr. Collins says he doesn't have any objection to the request, but your Rule 208 requires this notice to the candidate, and it's not been provided as of yet, despite the fact that the commission has had this complaint for months now. So now we're maybe getting to that point, depending on how the commission proceeds today. The other thing I wanted to mention is, your rules also call for, I think it calls for public administrative resolution or something. And I wrote Mr. Collins saying, we'd like to try to resolve this. And the response I got was completely unsatisfactory. The bottom line is Dr. Heap is trying to run a campaign, and we've basically been bombarded, by these complaints, and I think we've effectively rebutted them. But it was time to talk sort of resolution, because we would rather not have to spend all of our time dealing with this commission. It's not happened now, and you'll hear more about this later from me on the next agenda item. Now Mr. Collins is demanding money back from candidates. I think it's probably only a matter of time before we get that letter too. And under these circumstances, it's just Dr. Heap just does not want anything to do with this program anymore. He's requesting now that he be allowed to withdraw. I'll submit a letter to that effect. But right now we're afraid to really spend any money, because we're getting these, 3 candidates have gotten these notices of repayment, and it's just that the commission, and I know you'll continue in an enforcement action, but Dr. Heap never would have participated had he known what it would involve. And he doesn't want anything to do with this program, and I doubt he ever will again, based on just the kind of the Byzantine process that one finds oneself in when one is the subject of a complaint. So that's all I have to say. Thank you, Madam Chair.
Thank you, Mr. Lasota. Let me see. At this time, we're planning to take public comment on this item. If you could make sure to go to the React button icon on the toolbar and do a raised hand to indicate if you want to speak. Please keep your mic or phone on mute until we ask for your comment, and I'll call on individuals one at a time. When your name is called, please unmute yourself and then state your full name for the record before beginning your comments, and we request that you limit your comments to 3 minutes. If you need assistance, please you can use the chat function, and then I'll be sure just to make sure before we move on that everyone has an opportunity to be heard. Okay. So the first one that I see here is Gina Swoboda. If you want to go ahead and unmute and identify yourself.
Thank you so much. This is Gina Swoboda. I appreciate members of the commission. Thank you so much for your time today. Super quick comment. I just want to say we need candidates that run as participating candidates to comply fully with their campaign finance report. So if there is an invoice that is still open from Mesa Sign Shop, then the public really has no idea what the flow of money is. And I appreciate Mr. Lasota's comments that his client has decided he no longer wishes to have anything to do with this program. However, he ran on the program, he's in the program, the commission voted to keep him in the program. And it would be great for, election integrity that a lot of people talk a lot about, if they could just comply with the law. That's it. And I appreciate you. Thank you so much. Have a great day. Bye.
Thank you. And next I see Lisa Everett. If you can unmute and identify yourself.
I'm Lisa Everett, and I'm just a little concerned because Dr. Heap received the same instructions as every other candidate that runs through Clean Elections. So the rules were made clear, and it appears that the rules have been violated. And now that he has been caught, he wants to be fully released. And I do hope that the commission levies fines, because we do need election integrity. We do need people to follow the rules and to represent the public properly. So I am urging the commission to follow your own guidelines and do what is right for the voters. And Dr. Ralph Heap is not complying. That's all I have to say.
Thank you, Miss Everett. Let me see. I don't see any other raised hands. Is there anybody else who wanted to comment on this item? Okay. Mr. Lasota, did you want to make any further comments?
No, thank you, Madam Chair.
Yeah. So any discussion from the commissioners, or is there a motion from a member of the commission to move into executive session for legal advice?
I'll make a motion that we move into closed session for legal advice on this matter.
Is there a second?
I second that motion, Steve Titler.
Commissioner Crump has made the motion for executive session. Commissioner Titla has seconded. I'll call the roll. Commissioner Crump,
Aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
and chair votes aye. So with a vote of 4-0, we're moving into executive session. For this e-session, those attending are the commissioners, Craig Morgan, who's our independent legal counsel, and then I believe Angela for our minute taking.
We are all back from executive session.
Great, thank you. Does any commissioner want to make a motion regarding the order in MUR 26-06?
Yeah, this is Steve Titler. I'd like to make a motion to issue the order.
Issue the compliance order?
Yes.
Is there a second?
Madam,
I'll second
Chair,
it, Peyton.
I'm sorry, I heard two at the same time. Do you want to, Commissioner Crum, do you want to?
I wanted to propose an amendment to the motion. I don't know if you want to get the second first and then.
No, I'll take
well,
the second off.
Okay, I wanted to propose an amendment. I think Commissioner Titla's motion was to approve the proposed order. Is that what I heard? Okay.
Yes.
And I would like to propose that we amend it by removing Roman 4, paragraph Roman 4, subpart, sorry. Well, I guess it's under the actual order language at the end on page 2. So numeral 4, subpart B, which starts out all documents and communications reflecting Mesa Sign Shop.
So you want to remove that from the compliance order, number 4B?
Correct.
And Craig, maybe help me just to make sure, is it fine to just adopt that amendment, or does Commissioner Titla need to restate his motion?
I think the appropriate thing to do is, there's a motion, it wasn't seconded, restate the motion as it relates to, if someone wants to make another motion, I think you make a record that the first motion was not seconded. All right. I think someone makes a new motion with this amendment. And I think, as I understand the amendment, Madam Chair, it's to, I'm sorry, did I miss, was it to strike the entire paragraph or just clarify that the paragraph only applies to the candidate? I'm sorry.
Yeah, thank you, Mr. Morgan. That would be helpful, I think. So my proposed amendment to the motion is that number 4B be amended so that it's clear it only applies to the participating candidate and his campaign.
So, Madam Chair, if I may, members of the commission, I think the appropriate move then is just to clarify, make the motion to approve as amended by Commissioner Crump, and then go from there.
Okay, so do we need to restate it then?
I would, just to be careful,
sure.
yes.
Okay, so should Commissioner Titla do that since he did the first one, or does it matter?
I don't know that
Anybody
it
can make
matters at
motion?
this point. The first motion didn't get a second, so.
Sure, okay. Commissioner Crump, do you want to make that motion?
Sure. If it's all right with Commissioner Titla, then I'll just go ahead and do that. So I would make a motion that we approve MUR 26-06, the draft compliance order, that we approve that with the amendment in number 4B, that paragraph be amended to state that it only applies to the participating candidate and his campaign committee.
And is there?
I'll second that, Peyton.
So Commissioner Crump has made the motion to approve MUR 26-06 draft compliance order with the amendment that 4B be amended, that it only applies to the participating candidate and his campaign. Commissioner Peyton has seconded the motion, so I'll call the roll. Commissioner Crump?
Aye.
Commissioner Peyton?
Aye.
Commissioner Titla?
Aye.
And chair votes aye. With a vote of 4-0, the motion passes. Okay, item 5 is review, consideration, discussion, analysis, and possible action on repayment recommendations involving 3 participating candidates. Risa Lombardo, who's a participating candidate for governor, Scott Neely, a participating candidate for governor, and Dwayne Collier, participating candidate for Secretary of State. Commissioners, you have the letters sent by the executive director in your packet. The commission's independent legal advisor for this matter is Bill Richard and Samantha Fox of Richards and Moskowitz. My suggestion would be that we at least first hear from Tom Collins, our executive director, and then if the respondents and the representatives, which I believe Mr. Lasota said he's representing them, or at least maybe one of them today, and then we may want to go into executive session, just since this is the first time we're hearing about this item, to at least get some legal advice about sort of the framework of this process. So Tom, if you'd like to proceed, please just come with your opening statement on this matter.
Thank you, Madam Chair, Commissioners. So, as Madam Chair mentioned, I want to bring the Commission up to date on our efforts to understand how Ms. Lombardo, Mr. Collier, and Mr. Neely obtained and used, in some cases, Clean Elections Fund. Before I begin, I want to also make sure the record's clear on where we are procedurally. As you mentioned, the Commission has its own legal counsel, and I have counsel assisting me with this. And so I'm obviously not here to provide you legal advice to the Commission or tell you what you can or can't do. Obviously, we sent notice to the campaigns at the email addresses that they use, and by virtue of, I see Mr. Neely and Mr. Lasota, that it appears that all of the...
It's just for lunch again?
Where?
Oh, we're taking orders.
Okay.
Commissioner Titler, can you just mute yourself? Thank you. Sorry, Tom.
No. So, and there's a reason we're proceeding this way, because this is an ongoing effort, and ordinarily there would be good reason not to disclose anything sooner than we have to. Doing so creates some risk of evidentiary loss, some compromise, but we accept this here in order to ensure that respondents have additional notice of the concerns we have identified, and they will, as you identified already, Madam Chair, have an opportunity to respond to that. And I think that this is appropriate given the potential repayment obligations that we noted. It doesn't mean that what I present today reflects the entirety of the evidence we have or other evidence that we may obtain. As I mentioned in the letter specifically, we're not anticipating asking the Commission to take action today. But I think that we have developed sufficient evidence that the Commission needs to understand where we are and where I expect this to go. Now, let me be precise about what the issue is here. This is not a request that the Commission impose a penalty because it believes fraud occurred. This is a narrower question. The question is, under the rules, were these candidates entitled to the public funds they received? Clean elections funding is not money to which a candidate is automatically entitled. The candidate has to satisfy the statutory requirements for qualification before becoming entitled to public funding. And among the most fundamental requirements are the qualifying contributions. Those $5 contributions are not simply paperwork, but they're a mechanism by which a candidate demonstrates the required level of public support and becomes eligible for public funding. The Commission has an independent statutory responsibility to enforce the Act, to monitor candidate reports and financial records, and ensure that fund money is properly placed and spent, and ensure that money required to be returned is deposited to the fund. In our repayment rules, one rule that we're addressing here is that, consistent with the obligations under the Act, if there's a payment that's determined to be in excess of the payments to which the candidate was entitled, the candidate must repay that amount. So the question is essentially whether or not the candidates were entitled to receive the funding. And we have, at this point, substantial evidence about why the qualifying contribution process was not valid. We'll start with the data. It's not one isolated contribution here that got our attention. It's the relationship among the qualifying contributions attributed to these three separate statewide campaigns. And we've run a preliminary analysis of the data that is included in the exhibits. And that preliminary analysis shows something around 5,000 unique donor names. And about 74% of those are associated with more than one of these three candidates. And almost half of them are associated with all three candidates. So that means that nearly 3 out of 4 names in the combined donor pool appear with more than one of these candidates. And nearly 1 out of every 2 names appears with all 3 candidates. And then there are something like 400 or 500, in one case, that may be around 300 individuals, right? So you've got the bulk gave to at least 2, almost half gave to all 3, and then you've got a handful of candidates, a handful of donors that purportedly gave to just one of each of the individual candidates. And that identifies a pattern that is, itself anomalous. And we're not talking about 20 people or 50 people or even a few hundred people that might have been at a state party meeting. We're talking about something like 3,000 names associated with multiple candidates. And that means that the questions presented by the rest of this evidence are not confined to an isolated group of forms. It runs through a substantial portion of the qualifying contribution activity itself. And that really brings us to why the candidate's pre-funding financial activity is so important. So, as we talked about in the letters, the pre-qualification financial activity doesn't match the activities that the campaigns represented was occurring. And I want to be a little careful here about what that does and doesn't establish. There's no rule that says that a candidate has to spend a particular amount of money to collect qualifying contributions. And the law recognizes that candidates can receive substantial assistance without incurring reportable campaign expenses. I think we might hear a lot about this in a few minutes, but an individual can receive volunteer services may volunteer services without compensation, or a volunteer can absorb certain personal expenses like travel or use of property. Candidate can speak at certain privately furnished venues. The statute contains other specific exceptions for particular activities. So a campaign can certainly accomplish some things without spending money. But those exceptions do not explain away all of the financial activity here. These were statewide candidates who represented they had obtained thousands of separate $5 contributions from Arizona voters over a period of months. That activity on a substantial scale. Someone had to find thousands of people, someone had to communicate them, someone had the thousands of paper forms had to be obtained, distributed, completed, collected, organized, tracked, transported, and submitted. Thousands of $5 payments that supposedly had to be collected, maintained, and accounted for, and ultimately delivered to the campaign. Volunteer labor can explain some of the activity, but it doesn't explain all the goods and services, materials, communications, administration, and other resources that would be associated with the operation of that scale. And we have examples specifically in the Collier and the Neely letter about what ordinary statewide candidates on both sides of the aisle are doing. And these candidacies are, again, anomalous. And the statutory exceptions to the definition of contribution are important because they're specific. They exempt an individual's uncompensated volunteer services and certain incidental volunteer expenses, but there's no general exception for another person to simply supply a candidate campaign with what are ordinarily goods and services necessary to conduct a campaign and just call them volunteer. So look at what's actually reported. Scott Neely reported less than $400 in expenses and only $268 in seed money. Mr. Collier reported no pre-funding expenses and $55 in seed money. As the notice puts it, this is a campaign that paid nothing for advice, nothing on paper, no bank fees, nothing. Ms. Lombardo's first quarter campaign report similarly showed no seed or early contributions, no expenditures while she was supposedly accumulating qualifying contributions. Her bank statement showed only nominal balance during this period. Again, the point is not that a legitimate campaign must spend a particular amount of money. The point is that the reported financial activity is extraordinarily difficult, if not impossible, to reconcile with the scale of activity these campaigns represented was occurring. The volunteer exceptions only apply to those things that are provided without compensation or reimbursement and that are not, in converting sort of an industrial level signature gathering operation to volunteer is not something that you can just say and magically answers the question. For example, if a person's being paid to circulate petitions or canvass voters, perform voter conduct and other campaign fieldwork, or for another campaign, or for a group of the campaigns, and that same person is collecting qualifying contributions during the compensated operation, you can't just say, oh, and by the way, I'm going to volunteer for 2 minutes here and have you fill out this form over here. And I think we're going to hear something along those lines from Mr. Lasota. I do. But the relevant question is, what was the person being paid to do? Were the qualifying contributions collected during the same shifts where they were being paid? Were they being paid hourly? Transportation, supplies, voter lists, office space, all those resources, those aren't volunteer. So you can't make compensation disappear merely by characterizing one component of a field operation as volunteer activity. That's just not, there's nothing anywhere in the exceptions to contributions that Mr. Lasota has pointed to in the past that supports that. So if the explanation for how these campaigns obtain thousands of paper qualifying contributions while reporting almost no pre-qualification expenses is that volunteers collected them, but the people responsible for collecting those contributions were simultaneously being paid somewhere in a broader operation, obviously this volunteer application will turn out to be less than persuasive. In other words, the absence of campaign expenditures doesn't mean that there necessarily were no costs. It may instead mean the costs were borne somewhere else. And standing alone, that requires an investigation, but it doesn't stand alone here. Nearly 3/4, as we said, of the unique donor names are associated with more than one of these candidates, nearly half associated with all three. The campaigns relied heavily on paper qualifying forms, and despite that, the corresponding money does not appear in their campaign accounts during that period. So we have campaigns reporting little financial activity, no financial activity in any meaningful way, while simultaneously representing some substantial campaign activity was taking place. And the people, so the inference that I suspect the candidates are going to ask you to draw is that the absence of expenditures is explained away by volunteers, and they will ask you to reject the inference that follows from the evidence that we actually have. The extraordinary donor overlap, thousands of paper forms with virtually no costs associated, and no contemporaneous financial trail for the $5 contributions. In its place, they're going to ask you to infer from what the record does not show that there's an essentially cost-free operation, a large group of uncompensated volunteers sufficiently organized and dedicated to three largely unknown statewide candidates to locate thousands of voters, obtain thousands of paper qualifying forms, collect corresponding cash, right? Because we know, and we'll get to this later, that it wasn't checks, and ultimately deliver it to the campaigns. Well, that's a hypothetical, but that's not what the evidence shows. The actual evidence shows us that, the actual evidence shows the opposite. And this distinction matters because the commission is not being asked by the Rule 704 to presume the candidates were entitled to public funding and then require staff to disprove every conceivable innocent explanation. The question of the repayment rule is what the evidence establishes about the candidate's entitlement. And the commission should draw the most reasonable inference from the evidence it has, not replace the evidence with unsupported inferences drawn from what's missing. And, the expenses doesn't stop, the evidence doesn't stop with the missing expenses because the money suddenly appears. This is probably, for me at least, the most significant evidence we have. The qualifying contribution forms represent thousands of individual transactions purportedly occurring over a period of months. But the bank records do not show the money moving into the campaign accounts as those transactions occurred. Instead, Mr. Neely, his May bank statement shows a single in-person deposit, a cash deposit of $20,940 on May 12th, 1 week before he applied for funding. But his qualifying forms indicate that those, and his reports in the campaign finance system report those were collected over months. Mr. Collier had a single $18,060 cash deposit on May 29th, the day he filed his application for funding. Again, the forms purport to reflect the contributions over many months. And the money, nevertheless, somehow was deposited in one large cash deposit. Ms. Lombardo, the same thing, $21,485, an in-person deposit the day she filed her application for funding. And there's even an indication that she knew how to use Stripe. If candidates are using Stripe, typically they could have a large transfer from Stripe, but that tells us we know the money was in Stripe, which is what the electronic system the Secretary of State provides. So we have this common sequence. Thousands of $5 contributions supposedly collected over months, no corresponding campaign financial activity, and the money, the $5 alone, is absent from the campaign account, and then substantially all the qualifying contribution money appears in a single large deposit immediately before or on the date the funding is requested. So this is more than an unusual banking practice. It's a positive break in the financial evidence connecting the purported contributors to the money deposited by the campaigns. And that matters because the qualifying contribution is not just a form that has the voter's name. The candidate must actually receive $5 from that individual. The solicitor, whether it's a candidate signing as a solicitor or a different solicitor, signs, in fact, that they got $5 from that individual. So the temporal and possessory link between the money and the qualifying forms is broken. The bank records instead document the campaign's possession at a much later point in time, a large pool of money deposited through a single transaction immediately before funding is sought. And particularly where we're dealing with these lump sum deposits, the commission can't presume that each $5 came from an individual whose name appears on the qualifying contribution form, because that connection is precisely what the evidence is called into question. The temporal and possessory link between the money and the qualifying forms, together with the amount of cash deposited in these lump sum transactions, means the commission can't simply infer the link. There's a positive break in the financial evidence. And to illustrate this break precisely, Mr. Neely gave an interview to the Mirror where he admitted that the people who recruited him to run for governor also said they had volunteers to collect the $5 donations, but he declined to say who these people are. So, in other words, Mr. Neely confirmed that he knowingly took this cash with no apparent knowledge of its provenance, and then clammed up when he was asked who got him involved in this. And you can see the gears going when you read his comments to the Mirror. You can almost feel him saying, I think I might have said too much. And this break goes directly to the entitlement. The candidate's entitlement under the rule depends upon the qualifying contributions actually having occurred. The candidate cannot establish entitlement merely by producing thousands of forms and then pointing to a later pool of money equal to that $5 when the evidence doesn't establish that the money came from the individuals identified on those forms because of this very clear, very strong break in the chain between those qualifiers and the $5. To put it another way, collecting $5 over a period of months, where was the money? Was it in a shoebox somewhere? Was it under someone's mattress? The reason people use banks, in addition to the fact that the act mandates the financial activity be through one single campaign finance account, is because they don't want to be Uncle Billy in It's a Wonderful Life. So then we get to the fact that we now have evidence of the other end of the transaction. Purported contributors who have said that they did not make the contributions attributed to them. Just to look at the mirror story, Christopher Scott of Peoria looked at the records that said he had contributed $5 to all three, right? So Mr. Scott, we're to presume, I guess, that Mr. Scott would have sat there with 3 forms and had $15 and given $15 to all 3 candidates. And he told the Mirror that with 1,000% certainty, he did not make any of those contributions. And that's important because it precisely addresses, again, the evidentiary gap created in the bank records. The form says an individual provided $5. The bank records do not establish that the money came from that individual or any individual. And now individuals identified on those forms are saying they didn't provide any money at all. So each piece of the puzzle reinforces the other, and they all point in the same direction. Nearly 3/4 of the unique donor names are associated with multiple candidates, nearly half associated with all 3. Campaigns pre-funding financial activity doesn't reflect the operating cost of seeking thousands of individual contributions. The corresponding money does not appear in campaign accounts as those transactions supposedly occur. And that's not to say that they had to have every day someone had to go down to the bank and deposit $5, but it is to say that over the course of many months, it is irrational to not have put that money in the bank. We also know that it wasn't checks because, if they were checks, they would have been deposited in the account. So it's cash. So the commission doesn't need to presume away all of this evidence based on some claim of exceptions or what have you. And that takes us to the entitlement issue, right? 704B provides that the commission determines any portion of payments made to candidates was in excess of the payments to which the candidate was entitled. The candidate has to repay that amount. The rule distinguishes that what the candidate paid and what the candidate's entitled to receive are not the same. It establishes that the government issued the payment. The government may have issued a payment, but that doesn't establish entitlement. Entitlement depends upon the qualification, and that depends upon satisfying these statutory requirements. So the question is not whether the campaigns ultimately possessed an amount of money approximately equal to $5 multiplied by the forms they submitted. The question is whether or not the individual qualifying contributions represented by those forms actually occurred. And if they did not, they can't be counted towards qualification. And where the evidence breaks the connection between the purported individual contribution and the lump sum money deposited in cash either before or literally on the day that these folks applied for funding, the commission can't simply presume this missing element into existence. The positive break in the financial evidence is sufficient to require the commission to determine the candidates actually established the qualifying contributions necessary to complete entitlement in the first place. Now, I know I've gone on. I have a little bit more that I really think I need to get through because this is complex. Ms. Lombardo, there's an additional certification issue that we don't, frankly, have an entire answer to. As the records that we've received and reviewed from the Secretary's office indicate that she provided $4,300 or 4,300 qualifying contribution slips. The minimum for gubernatorial candidate's 4,000, there's a sampling process under 16950C that says that approval based on a sample requires you have to project at greater than 110% of the required quantity. So that's 4,400 qualifying contributions. And I had Mike check the math 3 times, so we know that's a real number. 4,300 is only like 107%, right? So mathematically, the indication from the Secretary's office is that the counties informed the Secretary's office they qualified on the random sample. The math based on the numbers we have in those same reports it's just not possible. So, we don't know why that happened or how that happened yet. We don't know if there's but we know that that's what the raw facts say. So I think that this requirement is conceptually pretty straightforward. Qualifying contributions attributed to each candidate have to actually satisfy the statutory requirement, and we don't have that established by the candidate. If the candidate did the candidate actually satisfy the qualification requirement? If the candidate did, the candidate would have been entitled to the funding. If the candidate didn't, then the candidate wasn't entitled to obtain public funding on the basis of that qualification. And if a candidate received public funding without satisfying the condition that created the entitlement, the payment exceeded the amount to which the candidate was entitled. And that's the circumstances addressed by R2 2704B1. I want to emphasize that this is distinct from the penalty process and penalties. We're not saying fraud occurred, therefore the penalty is 4.7 million. That's not at all what we're saying. We're not even saying fraud occurred. We're saying that the theory is that the amount of public funding to which each candidate was entitled compared to what the candidate received, and if the candidate received more than the candidate was entitled to, the difference needs to be repaid. And we issued a notice that goes to, we think that could be the full amount here. I also anticipate that there will be an argument made along the lines of, well, these candidates were certified and that's the end of the inquiry. In other words, once the secretary sends an email that says that the candidates were certified, there's nothing else to be done and the money is gone. But the whole point of 704B1 is to allow the commission to determine if the candidate received more of the money than they were entitled to. 16956A7 puts a burden on the commission to ensure that money is placed in candidate, to enforce the act and to ensure that money is placed in candidate accounts as authorized by the article and not otherwise. And certification itself obviously occurs based on the information available at the time. A certification based upon the representations that a candidate obtained thousands of valid $5 contributions can't transform contributions that we don't have the evidence actually occurred in that way into valid contributions retroactively whenever that's discovered. I mean, in other words, the fact that on the day they submitted, the Secretary of State and the counties did not know what had happened in the background is not itself validating of what happened before they made that certification. There's not a get away with it clause in the Clean Elections Act. Because that would effectively eliminate the commission's ability to do its duty under 16956A7 to enforce the act and ensure that monies are placed in candidate accounts or otherwise spent in accordance with the article. I want to spend a brief time on the issues with the accounting issues. Collier and Mr. Collier, Ms. Lombardo made substantial payments to a company called Bootstrap Campaigns. That's a Nevada company. We know though from the evidence that we've both submitted by the Lombardo campaign and the Collier campaign that there, with the mail house which is not identified was different. We know from going out and doing field work on the signs that the Collier signs were installed by a different company, and that's the contact on the Collier signs. And the Lombardo signs placement with the Neely signs and the Collier signs, I think creates strong evidence that that the signs were also, there's another vendor there as well. So that's a separate theory for those two candidates. Under the fact that those should have been reported properly or not, that's outlined in the repayment rules. So ultimately, this is public money, and the fund paid out to these candidates because they represented through the qualification process that they'd satisfied the statutory conditions of public financing. And we now have actual evidence that calls into question that. We have evidence that the factual basis for this believing that the $5 qualifiers and the $5 donations and the qualifying contributions, they're delinked. So the commission is not required and oughtn't be required to ignore that evidence because the fund made payments before the underlying problem was discovered. Otherwise, again, as I said, 6956A7 doesn't mean anything. So I want to be clear, I'm not asking the commission today to do anything. I'm not asking the commission to determine the repayment obligation. And there's nothing here that seeks to impose a penalty. The candidates are put on notice now, the evidence developed so far, the potential repayment amount announced, the need to preserve the relevant evidence. The notices advise them that, of all the authority that the commission has. And I anticipate that there will be a final repayment recommendation that we make after this. And the candidates will have an opportunity to respond. But the evidence here should be viewed in sequence and the inferences should be drawn based on the evidence, not based on the absence of evidence. We have an extraordinarily anomalous pattern of donor names. In this small set of 3 campaigns, we have contemporaneous financial activity that doesn't reflect an operation of this scale at all. We know that the corresponding money for these $5 qualifying contributions doesn't appear at all in the campaign accounts as those transactions occur. Rather, we had large lump sum deposits that appear immediately before, in fact, in 2 cases, on the very date the candidates sought public funding. And we have folks who were purportedly contributors now denying that they supplied contributions attributed to them. This sequence creates a positive break in the evidence connecting the individuals identified on the qualifying contribution forms to the money ultimately deposited with the application for funding. And the commission can't fill that break with a presumption that every $5 in a later lump sum deposit must have come from the individual named on the form. This is particularly true when almost half of the unique donor names appear across all 3 campaigns. Candidates' entitlement depends upon qualifying contributions actually having occurred. Payment is not entitlement. Qualification creates entitlement. If ultimately the evidence establishes these candidates did not actually obtain the qualifying contributions necessary to qualify, the commission, has to determine what they were actually entitled to receive. And if the fund paid more, the repayment is not a penalty. It's the return of public money paid in excess of the candidate's entitlement. And so, again, I'm not asking the commission to act today, but I felt it was important to provide, this information, and again, to provide as much notice to the candidates as possible, which we have done as they are here and can make some points now, or and they're here. So, Madam Chair, that I understand it went long, but that is my presentation on this at this time, unless you have any questions.
Thank you, Tom. Questions from the commissioners?
This is Peyton.
Yes. Commissioner Payton?
Yes, so Tom, we're not just going to rely on the newspaper to interview those people. I mean, the story or whatever.
Right.
We would, part of your investigation eventually would be to go through those people's $5 contribution forms and get to the bottom of this by our own deal.
Madam Chair, Commissioner Payton. So we have, I want to be a little careful here because, as I said at the outset, what I've presented to you today does not include all of the evidence that we have. We do have our own field work, and that field work is consistent with what the Mirror has reported. And as I said in my letter to these to the candidates, and I've said to you, we're not asking for an action today, but we will be continuing to do that. So in answer to your question, yes, that is underway. Yes, it gives us confidence that the reporting in the Mirror is correct. And yes, as I said to the candidates, and I say to you today, there is additional work we would like to do.
Okay, thank you.
I want to make sure that we're giving the representatives or the respondents an opportunity to speak. Scott Neely, I see that you're here online. Do you wish to make comments? And since you're muted, I can't hear you, so I don't know if you're if you want to unmute if you're available.
Hi, this is Scott Neely.
Oh,
So-
yes, please proceed.
So I only found out about this the day that the news article came out a couple of days ago. I haven't been given sufficient time to obtain counsel, and I really don't have any comment on the matter. Haven't engaged in any fraud, and I'm confident I will be exonerated soon. Thank you very much.
Thank you, Mr. Neely. And then Mr. Lasota, I believe you said you were representing, which candidates are you representing?
Lombardo and Collier.
Oh, okay, please proceed.
Thank you. The bottom line here is this is black helicopter material. I mean, this is a really far-fetched conspiracy theory that doesn't really make a lot of sense at any level. And I'd like to start with Mr. Collins's assertion that there was which basically is saying that I botched this when I gave you the money. That's what he's saying, is you got the money, you shouldn't have gotten it because the Secretary of State didn't do a proper analysis of the $5 contributions. Well, the time to bring that up is before you deposit millions of dollars into the candidate's account. Now, as it is, Mr. Collins is just wrong on that point. What Mr. Collins says is essentially that we didn't hit the Ms. Lombardo didn't hit the automatic qualification, which is true. She didn't. She didn't have 110% of the contribution she needed. But hopefully everyone can see this letter. This is from the Secretary of State's office to Ms. Lombardo. Madam Chair, is the screen being properly shared?
Yes, Mr. Lasota, I can see it. Yes.
Okay. So you see what he says up here. You filed candidate, you filed these contributions. The sample shows you don't have 110%. Pursuant to ARS 16-950C, all 4,300 qualifying contributions were forwarded to the county recorders for verification. So they were all sent to these county recorders and they were all verified. Now, if we go to another, and this was actually in the packet. I think this is exhibit 1 in Collins's letter to Lombardo. And this is what he points to, that well, she shouldn't have been qualified for funding. Well, this on this very email, you see this link, this from the Secretary of State's office. So if we look at Ms. Lombardo, she's line 31. We can scroll through this and see exactly what happened. So we have her. She starts off. She doesn't get the initial qualifying, and that is consistent with, that is true. And it even says that somewhere. Initial sampling, no, she didn't qualify there. So what do? We send 100% to all of the counties, and we have a record of them returning these. Returned, 519, 512, 518, qualified, yes. So in other words, what happens? She doesn't qualify initially, right? And she's not over 110%. So what the Secretary of State's office does is they send out every single one of these $5 contribution forms to the respective counties that they originate in, and they check every single form. And they come back and they say, yes, she's got enough qualifications. And then we get the May 19th letter. So Mr. Collins is just plain wrong. And he says he's been investigating this thing for months. I was able to determine this in about 24 hours. I'm stunned. And the other thing we didn't get is nobody with the campaign got a phone call. I mean, if Mr. Collins would have called me, I could have explained this to him, along with a lot of the other points that he makes. I mean, it's clear he's gotten all hopped up on this conspiracy theory, and it's caused him to basically ignore reality and try to take everyday things and turn them into something nefarious, which they're not. So this is basically, his letter's just wrong. And even if it's wrong on the facts, and even if it were right, let's think about what Mr. Collins is doing. He's telling a candidate that he improperly certified as qualifying to return the money. And when was this determination made? This determination was made on May 19th. That's what the letter says. So even if at that point Ms. Lombardo were short of signatures, she would have had a chance under the rules to go get more signatures. This is, yeah, here's the May 19th. So she was, so even under Mr. Collins' facts, which are not accurate, she was properly certified. Even if she weren't, what he's saying is due to me botching this, you were deprived of the opportunity to provide more $5 contributions to meet the $4,000 minimum. So give us back all your money, even though this could have been done back in May. You could have been collecting signatures. We don't know how far short you were. Maybe you were one signature short. We don't even know that she was short because he's produced no evidence that he was short. And in fact, the Secretary of State has certified that every single $5 contribution form was sent out to the counties, and they verified that she had enough signatures, or $5 contributions, I should say. So the letter, the credibility of the letter is zero. Let's talk about, Mr. Collins talks about the volunteers, or, how could she have had this many volunteers? And the first thing I'll say about that is I don't represent Scott Neely, but I would never tell Mr. Collins the identity of volunteers, because what he'll do next is he's going to go out and subpoena and badger those people too. He's already been investigating these donors, and his issue with them is they didn't give money in the past. Who cares? I thought we wanted more participation by people who have been inactive before. Also, he's complaining about volunteers, or suggesting it can't be done with volunteers. It has to be done with volunteers. ARS 16-946B4 says you cannot pay people to collect $5 contributions, period. and you cannot employ someone on your campaign to collect $5 contributions. I've got a client that is in a 6-year enforcement action. And that's one of the things Mr. Collins is saying is that, well, your program effectively pays for contributions. I dispute that, but it goes to show there's no the path of compliance appears to be a non-existent one. Either you rely on volunteers and Mr. Collins takes issue with that, or you have a different program and Mr. Collins says, oh, you needed to collect these from volunteers. Mr. Collins has said that, well, we're just relying on this candidate certification of their $5 contribution. That's baloney. The Secretary of State verified these, the county recorders verified these $5 contributions. They go through the signatures. And what do we have as the evidence? We have a media story where the reporter talks about 6 people who say they didn't give a contribution. This is out of what must be tens of thousands of total contributions. If we're talking 2 gubernatorial candidates and a Secretary of State's candidate. So as to the deposit of the $5 contributions, that's hardly atypical. And Mr. Collins even admitted there's no rule that says every time someone gives you a $5 contribution, you must run to the bank and deposit that $5 contribution. Not a rule. If Mr. Collins wants a rule like that, the commission is fond of passing rules that regulate candidates. He's not done so. You are legally entitled to keep that money in a safe, to deposit it in the bank. No difference. And Mr. Collins doesn't get to tell you that you've done something wrong on this point, because you've not. You don't have to deposit that money in a bank the minute you receive it. It's not uncommon for candidates to do it at the end when they feel they've qualified. In this instance, I know at least one, I don't remember, maybe it was both candidates, but the bank actually charged a processing fee for processing that much cash. Collecting $5 contributions is just easier with cash. I've done it myself. It's much easier that way. He didn't really talk about the certification. The form has long been confusing. I felt the exact same thing. When does one sign the certification form? I think so. Miss Lombardo thought that was her job to do, whether she got the $5 from the person or not. She just made a simple mistake, or that's probably even overstating it. The form is very confusing and lends itself to somebody doing that. Regardless, it's another complete nothing burger. Now, in terms of the it's okay. One of the other things that Mr. Collins, he said, well, the theory. I mean, I'm sorry, but we have candidates out there trying to run for office. And he has a theory, and he's telling them, you are going to have to pay back all of your money. Well, in Miss Lombardo's case, she spent, I think, over $1 million. Neely spent all of his money, right? He's not a candidate anymore. He lost. I think he came in 3rd place. So, and on this hunch, this theory, he's completely disrupting candidates, leaving a massive question mark. I mean, what is a candidate to do in this circumstance? And just based on Mr. Collins' theory, which is not supported by anything other than these black helicopter theories and a handful of people who say they didn't sign. We don't know. Maybe they're confused. Maybe we don't know who's telling the truth, whether those people are, whether maybe the reporter got it wrong. We have no idea, and he's sending this letter out without even calling me or the candidate. What I do know is this is, as I would say, what Mr. Neely said about himself is exactly true about both of my campaigns. The Daily Mirror or the Arizona Mirror article was the first I've ever heard of any of this stuff. The campaigns should not have been besmirched this way, based on what is really just a bunch of black helicopters type conspiracy theories. Couple other points. I'm trying to think what else Mr. Collins said in the letter, but I think that was about it. That first time donors and all this money is deposited at the same time, and how can you do this with volunteers? Again, you don't have a choice. The statute says you have to do it with volunteers. And if it's not a volunteer, Collins would certainly say that the money doesn't count towards a qualifying contribution. Again, I think we've really, and in his letter, he even cites that, well, the Green Party doesn't want these people. I think Mr. Collins has gone out of his way to try to target specific candidacies, again, based on just his dislike for that particular candidate or his personal belief that that particular candidate isn't a real candidate. That theory is irrelevant, and it doesn't make a lot of sense either, because Mr. Neely spent his money attacking Andy Biggs. So if this were why would anyone do that, right? If the theory is we're going to have Green Party candidates and they'll get some of the vote that would other goes to Democrats, why would we throw someone in there who spends millions of dollars attacking the eventual Republican nominee? None of it makes sense. I really wish Mr. Collins would have called me before he did this. He said he's being careful. He's not. There is nothing careful about this letter. It is a complete smear, and it leaves these candidates in limbo. It's not right. It's not fair. It's not based on any evidence. And I know people have done this in the past, made bulk deposits without being hassled by Mr. Collins. That's just the way it goes. Reports, I know people list in their reports block expenses without being hassled by Mr. Collins. If an additional detail needs to be provided, that's simply a reporting issue. Where the campaign finance report could be amended to provide that additional detail. That's not a fine. That's just an amended report. That's another nothing burger. And oh, by the way, I brought Mr. Collins evidence of significant omissions in the campaign finance reports of certain candidates, and he told me he's not doing anything about it. This is something out of the Twilight Zone, that he's got this theory and how did this happen and how did that happen, and a lot of words I frankly didn't understand, like the block in the chain of presumptions and the inferences. Look, that's there's nothing but smoke and mirrors in Mr. Collins's letter. There's nothing to rely on, and I think you should take action. I think you should reject this recommendation so you don't leave these candidates in a state of limbo. As it is, we're not giving the money back, period, end of story. It was earned. It was properly certified by Adrian Fontes, who did the job he's supposed to do, despite Mr. Collins claiming now, 3 months later, that he didn't. Obviously, a claim that's been made in error. And these candidates do not deserve this. Mr. Neely doesn't deserve it either. I don't represent him, but I can certainly understand why he's not in a hurry to give more names to Mr. Collins, because every name he gets sort of is another subpoena, another interview, and I think this has gone way too far. It's the job of this commission to put a stop to it. Now we're talking about donors are being investigated. We're talking about volunteers, and the sin of the donors is that they didn't donate before. So I think it's time for this to end. The letter is nothing but smoke and mirrors, and and sort of unsupported conspiracy theories. So with that, I'll stop talking.
Thank you, Mr. Lasota. I think you're still sharing your screen. Oh, there we go. Thank you. Does any commissioner want to make a motion for executive session?
I'll make a motion that we move to executive session for legal advice on this matter.
Is there a second?
I'll second it, Peyton.
Commissioner Crump has made the motion for executive session for legal advice. Commissioner Payton has seconded. I'll call the roll. Commissioner Crump?
Aye.
Commissioner Payton?
Aye.
Commissioner Titla?
Aye.
And chair votes aye. So by 4-0, we're going to move into executive session. For those attending, again, it's the commissioners. Bill Richards and Samantha Fox are our independent legal advisors, and then Angela for our minutes.
Madam Chair, can I just note, I got to be in court at 1:30, so I may be in and out, but oh, looks like they're done. So.
Hey, in the DST, Mirko versus DST case, Mirko
We are back from executive session.
Perfect. Thank you. Just making sure all the commissioners made it here. Okay. So we're back in open session. Any further discussion by the commissioners? If not, is there a motion regarding the repayment recommendations?
Yeah, Madam Chair, I'd like to make a motion.
Yes, Commissioner Crump.
All right. So I would move that the commissioners vote to provide the following direction to the executive director regarding the information contained in his letter dated August 25th, 2026 to candidate Risa Lombardo. The information provided to the commissioners in Executive Director Collins' August 25th, 2026 letter provides sufficient cause to initiate proceedings that include completion of an investigation and submission to the commissioners of a final report and recommendation regarding whether to issue, and if so, the appropriate terms for a repayment order to candidate Risa Lombardo in connection with matters addressed by the executive director's letter. Therefore, under this motion, the commission directs the executive director to complete the investigation discussed in his August 25th, 26 letter to candidate Lombardo and provide the commissioners by hopefully by the September regular meeting, but no later than our October regular meeting of 2026, a final report and recommendation regarding whether to issue, and if so, the appropriate terms for a repayment order to candidate Risa Lombardo, so that the commission may consider and or act upon any such recommendation at an appropriately noticed meeting of the commission. And the executive director is authorized to utilize all powers and authority of the commission in completing his investigation regarding candidate Lombardo, including issuance and enforcement of subpoenas to witnesses to compel attendance and testimony, and issuance and enforcement of subpoenas for production of books, papers, records, or other material records, as all as authorized by ARS 16-956B.
Is there a second?
I second
I'll
that
second
motion.
Commissioner Crump has made a motion to provide direction to the executive director regarding Risa Lombardo. As Commissioner Crump explained, Commissioner Timpla has seconded the motion. I'll call the roll. Commissioner Crump,
Aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
Chair votes aye. Voted 4-0 on that motion. It passes. Is any commissioner have another motion?
Yes, Madam Chair, with your indulgence, I have a second motion.
Yes, Commissioner Crump, please proceed.
I move that the commission vote to provide the following direction to the executive director regarding information contained in his letter dated August 25th, 2026 to candidate Dwayne Collier. The information provided to the commissioners in Executive Director Collins' August 25th, 26 letter provides sufficient cause to initiate proceedings that include completion of an investigation and submission to the commissioners of a final report and recommendation regarding whether to issue, and if so, the appropriate terms for a repayment order to candidate Dwayne Collier in connection with matters addressed by the executive director's letter. Therefore, the commission directs the executive director to complete the investigation discussed in his August 25th, 26 letter to candidate Collier and provide the commissioners hopefully by the September regular meeting of this year, but no later than our October regular meeting of this year, a final report and recommendation regarding whether to issue, and if so, the appropriate terms for a repayment order to candidate Dwayne Collier, so that the commission may consider and, back to where I was. So that the commission may consider and or act upon any such recommendation at an appropriately noticed meeting of the commission. The executive director is authorized to utilize all powers and authority of the commission in completing his investigation regarding candidate Collier, including issuance and enforcement of subpoenas to witnesses to compel attendance and testimony, and issuance and enforcement of subpoenas for production of books, papers, records, and or other material records, all as authorized by ARS 16-956B.
Commissioner, is there a second?
I second.
Okay, Commissioner Crump has made a motion to provide direction to the executive director regarding Dwayne Collier, and Commissioner Titla has seconded that motion. I'll call the roll. Commissioner Crump,
Aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
Chair votes aye. With a vote of 4-0, the motion passes. And do we have any other motions?
Yes, Madam Chair, I do have one third motion.
Yes, continue.
I move that the commission vote to provide the following direction to the executive director regarding information contained in his letter dated August 25th, 2026 to candidate Scott Neely. The information provided to the commission in the executive director Collins August 25th, 2026 letter provides sufficient cause to initiate proceedings that include completion of an investigation and submission to the commissioners of a final report and recommendation regarding whether to issue, and if so, the appropriate terms for a repayment order to candidate Scott Neely in connection with the matters addressed by the executive director's letter. Therefore, the commission directs the executive director to complete the investigation discussed in his August 25th, 2026 letter to candidate Neely, and provide the commissioners, hopefully by the September regular meeting of the commission this year, on no later than the October regular meeting of the commissioners this year, a final report and recommendation regarding whether to issue, and if so, the appropriate terms for a repayment order to candidate Scott Neely, so that the commission may consider and or act upon any such recommendation at an appropriately noticed meeting of the commission. The executive director is authorized to utilize all powers and authority of the commission in completing his investigation regarding candidate Neely, including issuance and enforcement of subpoenas to witnesses to compel attendance and testimony, and issuance and enforcement of subpoenas for production of books, papers, records, or other material records, all as authorized by ARS 16-956B.
Thank you, Commissioner Crump. Is there a second?
I second.
Okay, Commissioner Crump has made a motion to provide direction to the executive director regarding Scott Neely. Commissioner Titla has seconded. I'll call the roll. Commissioner Crump,
Aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
and chair votes aye. With a vote of 4-0, the motion passes. That concludes that item. We're going to be moving now to item number 6, which is a discussion and possible action on an administrative fine involving Gwendolyn Gwen Johnston, a participating candidate for legislature, for failure to appear at a commission-sponsored debate. Commissioners, you have the relevant materials in your packets, and then I'll have the executive director make a statement. If Ms. Johnson or her representative is here, they may speak. So Tom, if you want to please proceed. I get the other instruction, guys. Oh, and if we could just make sure everyone's muted. Thank you.
Madam Chair, thank you. This is a little bit different thing. We have a Rule 107, that says that, if you are a participating candidate, you're obligated to attend a commission debate unless you've sought a prior excuse. In this case, Ms. Johnston did not attend, and as I noted in my letter to her, she hadn't taken the training before this. The training goes into this, but on the other hand, she is working with a very experienced former clean elections candidate. You have her response. I don't know that I feel like I ought to characterize it at all, unless you have questions about it. The rule here is not very complicated. It says if you having missed, if your your later excuse doesn't fit within the categories there, then you're fined $500. My read of the response is I don't think it really gets at those excuses. So I think the $500 fine is appropriate, but I'll take any questions.
Commissioners, do you have any questions? Tom, I just wanted to, I guess, to confirm. So there, I guess it looks like in her statement, it seems that she said she was first notified on May 16th. But it does not look like she reached out to any staff before the May 19th debate. Is that?
No, we don't have any record until the records we provided respecting the staff members' efforts to contact her on the day of. So our log, contact log that I think is in the packet,
Yes.
that's the complete communication. Part of this has to do with the expectation that the candidate, is to know what the candidate's obligations are. We do outreach, but we do rely on candidates having awareness of their obligations. So again, I mean, I don't know that it was not a failure of notice, if that makes it.
Sure.
If the notice is not the notice that the candidate would have preferred, I don't think that's the standard the rule articulates.
Did any commissioners have any questions for Tom? Is Ms. Johnston or any representative for Ms. Johnston online wishing to speak? I don't know that I see anybody. Okay. Is there any motion from Commissioner regarding the administrative fine?
Yeah, Madam Chair, I would make a motion that we impose administrative fine of $500 on participating candidate Gwen Johnston for failure to appear at the debate.
Is there a second?
I'll second it, Peyton.
Commissioner Crump has made the motion for the administrative fine of $500 to Gwen Johnston for failing to appear for a debate. Commissioner Peyton has seconded. I'll call the roll. Commissioner Crump?
Aye.
Commissioner Peyton?
Aye.
Commissioner Titla?
Aye.
Chair votes aye. So vote of 4-0, the motion passes. This is the time now, item number 7, for consideration of comments and suggestions from the public. Please limit your comments to no more than 3 minutes. So if you're a member of the public and wish to make a comment, please use that raise hand feature in the icon bar in the Zoom, and I'll call on individuals one at a time. When your name is called, please unmute yourself and state your full name for the record before beginning your comments. Does anyone on Zoom wish to make a comment? Okay, don't see any. So action taken as a result of public comment, of course, was always limited to directing staff, studying the matter, or rescheduling for further consideration. Since we have none, public may also submit comments by email at ccec@azcleanelections.gov. Item number 8, at this time, I'm open to a motion to adjourn.
Madam Chair, I move that we adjourn.
Is there a second?
I'll second
I
it, Peyton.
second.
Okay, I heard Mr. Peyton. So Commissioner Crump has made the motion to adjourn with Commissioner Peyton seconding. I'll call the roll. Commissioner Crump?
Aye.
Commissioner Peyton?
Aye.
Commissioner Titla?
Aye.
And Chair votes aye with a vote of 4-0.